let's continue, please. Our next roundtable is with Guillermo Lazcoz and Estrella Gutiérrez. First, Guillermo will give a presentation about human oversight for the use of AI by public administrations, insights from the proposed Artificial Intelligence Act. Guillermo is legal advisor and researcher at CIBERER, which is the Biomedic Research Center of Rare Diseases. He has recently presented his PhD thesis on governance and human oversight of automated decision-making based on profiling in the Basque University. And the floor is yours. Okay. You can start when you want.
I use this one?
Yeah, you can.
Okay. Can you hear me well? Not. I don't know. Yeah, okay. Thank you, Professor Gimeno. Well, let me start with a word of gratitude to the organizer, even if, I tweeted this some days ago, but it is worth repeating that many members of the of this regulation research group of the University of Valencia have inspired my legal research on AI, Alba, Adrián, Lorenzo, Andrés, and so on. And therefore, it is a real pleasure to be invited to this forum. And well, I will talk about my PhD topic, human oversight. I still feel that this topic remains a bit unexplored in the legal literature, at least if we compare the legal literature to the amount of scientific work that we find nowadays on human-computer interaction. So I wanted to start with some clarifications. Well, if we pay attention to the European policy documents on the regulation of AI, human oversight as a regulatory requirement includes different forms of human involvement required by law, human intervention, human control, human review, in automated decision-making processes where AI systems are used. Here in this slide, So, I wanted to make some clarifications on the argot for this presentation. Now, as you know, we can differentiate two main phases or stages for AI systems: the design and development phase, and the use or implementation phase, which, according to the AI Act proposal, begins when the AI system is placed on the market or put into service. In the first phase, the design and development phase, the main actor is the provider, who develops an AI system with a view to placing it on the market. And regarding the use phase, the main actor is the user or developer. This is any natural or legal person using an AI system under its authority. In the Commission's proposal, April 2021, we call them users. In the last consolidated compromise text of the European Parliament, we call them deployers. And under the data protection law, those users or deployers will probably also be data controllers. And regarding or focusing on the decision-making process, we have the implemented AI system that is overseen by a human operator or a human agent, and the natural persons affected by those decisions. Okay, this is only applicable for those decision-making processes where a human is required to intervene or oversee that decision-making process. So, enough clarifications. And moving forward, I will first provide a bit of context on the analysis of the human oversight in the GDPR, which applies to most of the public administrations pretending to use AI systems that process personal data. And then I will talk about the flaws of this regulatory ecosystem of the GDPR. And after that, I will go with the AI Act proposal, first with the Commission's version, April 2021, and then with some thoughts on the compromise text that was published last week from the European Parliament. So, human intervention or human oversight in the GDPR. The structure of Article 22, which prohibits decisions based solely on automated processing, is the following. Under a risk-based regulatory perspective, only AI systems processing personal data that produce legal or significant effects fall under Article 22. The general provision in paragraph 1 means that decisions producing a legal or significant effect that contain a human in the loop are lawful. In other words, the automated processing that includes a human intervention before such effects are produced is lawful. However, decisions having such effect and based solely on automated decisions are accepted under some circumstances, and those are the exceptions in paragraph 2, Article 22. These exceptions require the adoption of safeguards for data subjects' rights, and among others, we will find there human intervention out of the loop. This intervention looks more like a review of the automated decision, and it is connected to the rights of data subjects to express their views and also to contest the fully automated decision. Unfortunately, the GDPR does not tell us how this human intervention should be. Yet the extinct working party of Article 29 left us some clues in the guidelines on ADM and profiling that were later endorsed by the European Data Protection Board. According to those guidelines, human intervention in or out of the loop has to be meaningful. Meaningful meaning that it's not enough a formal kind of human intervention, like rubber stamping human intervention, and also that human intervention should be carried out by someone who has authority and competence to change that decision, and that the analysis of the outcome should take into account all the data available in that decision process context. Furthermore, if we look at human oversight in the GDPR from its nuclear accountability principle, we can find there an interesting legal perspective. From this perspective, human intervention is an organizational measure to mitigate risks in personal data processing, meaning that the GDPR requires, at least for high-risk data processing, when a data protection impact assessment has to be carried out, the GDPR here requires the controllers to justify how humans are integrated into the decision-making process and to demonstrate that this humans' intervention is effective as an organizational measure to comply with Article 22. And okay, so this is Article 22, and let's see the flaws of this regulatory framework. So I think that GDPR contains good ideas on how to build flexible but compliant human AI decision-making processes. However, the GDPR is not meant to regulate the whole life cycle of an AI system. The evidence shows that human oversight is very much determined, not only determined, also constricted by how a system is actually designed. And even if the GDPR, we find that many times will be applicable to personal data processing that occurs on AI systems training and validation processes, the fact is that it is out of the scope how human oversight is actually integrated into the design and development of the systems. So, the GDPR is not aimed to provide, let's say, some human oversight by design. For that, we need to look at further regulation solutions, and for example, we can find sectoral laws that address the design and development of AI systems. This is the case of the medical device regulation, also the in vitro device regulations for AI systems with a medical purpose. But unfortunately, if we looked at those sectoral laws, the particular obligations for software, including AI systems, in order to be properly evaluated as medical devices, do not include any provision on the human-machine interface. So, and therefore, we do not find a solution for this Achilles heel of human oversight in the GDPR in those sectoral laws. So, April 2021, following years of deliberation about a regulatory response to artificial intelligence, the Commission presents the already mentioned and discussed AI Act proposal. I'm not the official lawyer of these proposals, but it seems like I am in this seminar, so I have no time to go into the general structure, but I think that we have mentioned already what is important there. And I just wanted to share that apart from prohibiting an acceptable risk system, the proposal focuses on the governance of what it calls high-risk AI systems, and there human oversight becomes a mandatory requirement for high-risk systems, which states that you can see that AI systems shall be designed and developed by providers in such a way, including appropriate human-machine interface tools, that they can be effectively overseen by natural persons. The proposal adds that human oversight is aimed at preventing or minimizing the risks to health, safety, or fundamental rights, and also states how a provider should build AI systems that can be effectively overseen by natural persons by implementing in the system or identifying and communicating measures to, among others, understand its capacities and limitations, remain aware of the possible tendency of automatically relying on it, and to be able to correctly interpret it and in any particular situation to decide not to use it. So, a bit of interpretability, a bit of explainability, prevention of automation and complacency bias, effective control over the system, and the requirement to communicate all these measures to users or deployers. No? Looks good, at least in my view. Still, there was some room for improvement, and the compromise text that was released last week from the European Parliament added some improvements, at least for me. First, on the orange thing, even if I am not really a big fan of general principles, I have to admit that I liked that human agency and oversight was included as a general principle applicable to all AI systems. The principle means that AI systems shall be developed and used as a tool that serves people, respects human dignity and personal autonomy, and that is functioning in a way that can be appropriately controlled and overseen by humans. Two good things here. The first one is that this principle is not only applicable to high-risk AI systems, but also to the rest of AI systems. This is something good. And also that the principle goes beyond human oversight as a technical kind of approach, and talks about also about human agency, dignity, and personal autonomy. I think that this is a good thing there. Apart from that, and back to the high-risk systems, we find new obligations for users or deployers at the implementation or use stage or phase. Among other obligations, there I talk about to implement human oversight according to the requirements laid down in these regulations, and not only to follow the measures communicated by the provider. This is something new, and to ensure that the natural persons assigned to ensure human oversight are competent, properly qualified, and trained, and have the necessary resources. This was already stated on recital 48 of the Commission's version, but it was not translated into actual obligations, and I think that this is a big step on this law. And yeah, finally, it is included the obligation to carry out fundamental rights impact assessment for high-risk AI systems, which includes the requirement to justify how human oversight is ensured. And here is where I find many similarities between this idea and how the GDPR requires for data protection impact assessments to justify how human intervention is included in the decision-making process to guarantee the rights of data subjects. So to conclude, last slide. Let me finish with a conclusion and a few concerns. So first, the conclusion: we find human oversight by design at the heart of the AI Act proposal and dealing with the vulnerabilities of the GDPR. Furthermore, I want to believe that the prominent role of human oversight in the AI Act will boost the compliance of human intervention in the GDPR. Andrés, no me llames iluso porque tenga una ilusión. And yeah, my concerns, as you will see there, are more medium, long-term kind of harmful consequences for human oversight. First, it is true that according to the proposal, providers have to include measures that make humans aware of the possible tendency of automatically relying on the systems. We are talking here about automation bias. However, I believe that this is not enough. First, humans will for sure automatically rely on AI systems, even if we want or not. And indeed, in many times, we want humans to rely on AI systems. Anyway, my point is that preventing harm stemming from automation and complacency bias requires more than implementing just technical measures by the provider in the design and development phases, because evidence shows that this issue will require more like a continuous evaluation of the real-world use of those systems. And second, the more difficult one, how can we prevent unwanted de-skilling? Evidence shows that humans that rely on technology will inevitably lose skills that are automated. We all now get lost without Google Maps. We are completely de-skilled. And it is not something bad in every case that we get unskilled in some skills, but we will, as a democracy, we will probably want to decide where we want to be de-skilled and where not. So my question would be, is there any regulatory solution that may allow us to evaluate how a particular system de-skills humans on control, and therefore if this evaluation allows us to avoid unwanted de-skilling? And that was all.
Thank you. Thank you very much, Guillermo. We learned a lot. And now we will move on to Estrella Gutiérrez's presentation. She's assistant professor of constitutional law at the Universidad Complutense de Madrid. But today she will blend herself in the administrative law movement and she will speak about public contracts and the title of her presentation is Mapping Innovation in Public Health Sector, Challenges and Opportunities in Public Procurement of AI-Driven Solutions.
Vale, que son... Es para ponerlo en...
Claro, lo que pasa... Espera, tenemos que compartir primero porque si no... 1 second, sorry. I don't know if we're sharing screen.
Well, meanwhile, Clàudia is dealing with technical issues. I would like to thank the organization, the Universidad de Valencia, Professor Andrés Boix for this invitation, and well, I have been following some of the conferences which have been quite interesting. Not all of them because I had to work as well, and well, in fact, she has presented me as a constitutional law lecturer, but today I'm dealing with public procurement. So I must say that I am spyware, I don't know where, if in constitutional law or administrative law, but the fact is that for a constitutional law perspective, to understand the impact, the individual and social impacts of artificial intelligence in rights and freedoms, we need the administrative law. We cannot forget administrative law, because administrative law deals as well with technical requirements. I mean, soft law in administrative law is quite important. For example, let's think about construction, building. In building, the code of building, the Spanish code of building, integrates a lot of technical requirements. So we need to deal with this. So, well, let me say, yes. No, that's okay. It's okay. So, what is the starting point of my research? In fact, my starting point are two research projects funded by the Ministry of Science and these two research projects have been conducted by the University Carlos III. So I'm a spyware as well in other universities. So, and the first phase of the first project was about the impact of artificial intelligence in public services and was a legal analysis of the scope of that impact and the consequences in healthcare. So the main research task in this phase one was what is actually being procured, because what are public administrations doing? What are the artificial intelligence-driven solutions being procured? So because it's important, we are putting the focus, we are focusing on the private sector, what is Google, what is Microsoft, what is Facebook doing, but the public sector is procuring a lot of artificial intelligence solutions. So, and with what safeguards? We don't know. Well, I have an idea now. I want to share that idea about the safeguards. So after reviewing the tender documentations, the next step was to produce a relevant database to map tenders of artificial intelligence in the public sector, with a special focus on national health care system. What was the expected results in this first phase? To identify the interdependencies between the inherent risks of artificial intelligence and the inherent risk inside the public procurement process, because there have also other inherent risks. For example, vendor lock-in effects, the dependency of the public administration of the contractors, of the vendors. The first results were published in the Indiana Journal of global legal studies will be available for free in a future, but now it's not open. I'm sorry. But if you are maybe interested in the results, because different researchers published our outcomes and deliverables, so you can ask me and see what we can do. So the next phase. Okay, it's very loud. I'm sorry. So, no, but maybe I'm sorry. Thank you. Better? Is better? Yeah. I'm sorry. Well, the second phase of the project was is not finished. It's artificial intelligence in the national healthcare system, the Spanish national healthcare system, solutions to specific legal problems. So the second concern is, are governments acquiring ethical and trustworthy artificial intelligence? If we follow the scheme proposed by the high-level expert group of the European Commission, are we aligned? Are public administrations aligned with these principles? Well, and how? Now we are analyzing the technical and legal safeguards provided in the tender documents. So we are analyzing the tender documents, and tender documents are quite wide. For example, public consultations to the market. That means it's a pre-stage of the public procurement, and in this stage, the public administration asks to the market what are the, for example, the artificial intelligence solutions that are in production, that are commercialized, or what can be the options of the solutions to a specific problem. So what are the expected results? Produce a guidance for public purchasers in the area of healthcare system. Why? Because we have just a few guidance, just a few guidelines. For example, I will refer in my concluding remarks that just, for example, for the World Economic Forum, we have a guidance. We have guidance in the UK, which are quite interesting, and some guidance about the standard clauses to be incorporated into the final contract between the contracting authority and the vendor. So what type of public purchases are we interested in our research project? We follow these taxonomies proposed by Weser, I don't know if the pronunciation is properly, and Mueller. And they identify 3 taxonomies of public procurement and innovation. I have adapted the taxonomies to artificial intelligence, as it is real innovation, artificial intelligence, application of artificial intelligence in many areas of the domains of the public sector is real innovation. So what we have seen is we have artificial intelligence to innovate public procurement. Most of the literature review is focused on this part, how to use artificial intelligence to innovate the public procurement and the procedures. For example, in selecting the bidders, okay? So selecting criteria of bidders. Or for example, the second taxonomy would be public procurement of artificial intelligence, so for special use cases. So, and the next one is public procurement for artificial intelligence. In this way, the answer is, or the question is, how can public procurement of artificial intelligence be used as a demand-side tool to drive innovation public policies? So for our purposes, the purposes of the research projects, we focus in the 2 circled areas. Well, according to the literature review, we made a search in Scopus database and Dialnet. As you can see, there are not too much literature about it. So specifically focusing on public procurement. And the literature that we have is very limited in the scope in relation to topics and insights. What kind of insights can we gain from this literature? For example, we have seen the use of artificial intelligence to enhance, innovate public procurement procedures. And the second topic is specific purchases of artificial intelligence solutions. For example, in relation to fraud, to detection of fraud, corruption, competition. And sometimes, for example, in the abstract or even in the title, you see the term, the key word, artificial intelligence. But if you look into the paper, it's just only a keyword to claim, to gain attention. But there is not real insight about the analysis of artificial intelligence. So we have a lacune, real lacunes. So our purpose was to analyze the tender documents. I mentioned before that, for example, we pay attention not only to the market consultations, the public market consultations, but also, I am sorry for my previous speakers, technical requirements. We need to see the technical requirements. Are they introducing safeguards or not? And also administrative requirements, which have to be, for example, with intellectual property issues, the type of procuring procedure, for example, the specific requirements to the bidders, and so on. Well, so in order to extract the tender documentation, we have used e-tendering platform from the European Union, the Spanish public sector procurement platform, which is a nightmare. It's like the labyrinth of the Minotaur, to look for something specific, because the type of internal search that the search machine that the platform has is not usable, is not easy for a non-expert in public procurement. For example, a criterion of search is the CPV, is the Common Procurement Vocabulary used by the European Union. The type of contracting authority, the type of contract, but for example, a specific criterion is the public procurement of innovation. We have seen 161 tenders, so this means it's really a huge amount to look into the specific procedures. For example, we have looked into for the contracting authority profiles. This is much easier to find something interesting. For example, using keywords. Keywords is permitted in the profile contractor of Madrid, Andalusia, and Catalonia, for example, which makes easier our search. And for example, the website of the Recovery, Transformation and Resilient Plan platform as well. But this is not very useful. Sometimes you need to check contract by contract, which is an amazing task. So, and also we use, let me use this term from cybersecurity environments, which is force brute attack, Googling by Googling. So finally, what we did, homemade data mining to gain insights, tender documents. When I say homemade, it's not data mining, but an adaptation for no ordinary user as me. Well, this is the platform, so you can see it's impossible to look something to extract in some knowledge about it. So, what was the period of time from 2015 to 2023? This year, we have identified 45 tenders. 13 of them consist on public procurement of innovation, which has two modalities: public procurement of innovative technology and pre-commercial public procurement. I'm not going to explain this kind of, because this is very, very administrative, but most of these types of procuring basically are focused on innovation. What public administration want to acquire innovative products. Usually this kind of public procurement policies, because they are policies, uses these tools. And we identify 8 tenders associated to the plan of recovery, transformation, and resilience. Well, this is the scheme. This is a scheme for commercial procurement. So in the first phase, we are working with prototypes. A prototype of a product, for example, a prototype of an artificial intelligence system or an artificial intelligence application, and we want that the vendors, the market, provide us with a solution in order to commercialize that solution. The second phase would be procurement of innovative technology. That means with a solution which is more or less developed, more than a prototype, in a scale of tender, in a scale of technology readiness level, which is used by the European Commission, for example, to assign innovation and fundings to innovation. We may talk about 7 and 8 in the scale. Well, taxonomies of public what is acquiring the public administration in the healthcare sector. First, artificial intelligence-driven solutions to support clinical decision making, biomedical research, care management and optimization of available healthcare resources. For example, improving hospital triage systems, admission of patients in emergency, for example, deployment of data and IT infrastructures to support artificial intelligence-driven processes. For example, creation of data lakes, servers to deal with artificial intelligence, because the capacity, the energy consumption of these systems is quite demanding. So we need servers, interoperable infrastructures to share healthcare information, statistical and that's analysis. For example, in the European Union, we have seen a tender. I'm sorry, sometimes my tongue doesn't work properly. And fraud detection in sick leave, at least 2 contracts. Analysis of sentiment and perception using social networks about what are the opinions of public in relation to public healthcare system. And here I'm not going to focus on that, because this presentation will be made available for you if you want. But these are some of the contracts we have been analyzing. For example, this is of the Ministry of Healthcare in Spain, which is very old. It is dated from 2016. And so luckily the tender documents were not available. So I cannot say what was for example, the technical prescriptions in order to include safeguards. But from that date, and even earlier, from 2015, we have seen some tenders. For example, Xunta de Galicia, as well, for cancer detection, is using it procured a contract for cancer detection. For example, this is a very amazing contract, because it combined, it was a contract which was tendered by 2 autonomous communities, Valencia and Gran Canarias. This situation is regulated in the directive of public procurement, the European Directive of 2014, that 2 different contracting authorities can associate to tender a contract. And for example, this one was to was to support clinical decision in relation to chronic diseases, especially oncological and cardiovascular diseases. And also to optimize, the goal of the contract was to optimize the protocols in cases where there was a severity in the disease. For example, the Autonomous Community of Madrid, I've seen that you work with genomics, Guillermo. For example, this contract is quite interesting as well. The development of a platform called Medio Genomics for genomic study of patients. And the data sources are coming from the electronic healthcare records, and also using natural language processing and machine learning techniques. Sometimes the procurement documents identify the type of technique to be used by the final vendor. For example, this is Ibermutua for fraud detect in relation to sick leave, and the Autonomous Community of Aragon for tele-rehabilitation and I'm sorry, I didn't translate it, I'm sorry, but from home. So that means it's a way to control patients by distance, okay? Mm-hmm. Well, what's the problem we have found after analyzing the tender documents? What are the main risks, what we have identified? First of all, the analysis of the technical specifications and even the administrative requirements have forgotten the whole life cycle of artificial intelligence. This is the whole life cycle. The whole life cycle is identified by ENISA, which is the cybersecurity agency of the European Union, which is very interesting. And for example, I have to say that the model training is very important. We haven't seen, with some exception, we haven't seen any reference to the model training or model tuning, or how we are going to proceed with the maintenance of the contract or the solution. Well, absolute absence of a data protection impact assessment or artificial intelligence impact assessment. I have to recall that, for example, in Canada, we have the directive on decision automated making provides a scheme for impact assessments of artificial intelligence, just only in one contract. In this one, which is for fraud detection in sick leave. In addition, we have seen a lack of implementation of data governance policies, selection, preparation, representativeness, absence of bias or discrimination, error, duplication, gaps in the data that we have, the primary data, nor artificial intelligence governance policies. Be careful, because I think the proposal of regulation lacks as well of artificial intelligence governance policies. Well, there is an article referring to Article 10 referring to data governance policies, but it's not the same. It's not the same. One thing is data governance policy, and another thing is artificial intelligence governance policy. For example, if you see the structure and the content of this ISO technical standard, explains very well what is an artificial intelligence governance policy. It takes into account the goals of the organization, the data governance policies introduced, the main roles of the stakeholders involved in this artificial intelligence system, and so on. So there are different layers of governance in this technical standard proposed. Is very recent, proposed by ISO. And for example, in the associated contract between the Generalitat Valenciana and Gran Canarias, in this contract, we have seen somehow some specifications relating to data governance policies, but very, very soft. And for example, in this one, in the EGASAT file for sick leave prediction as well, we have seen some references to data governance policies, but not very clear, very vague. Lack of techniques to ensure explainability of models, especially problematic in black box models. For example, these are in which black box models are used in this one, in 2018 classification model of health emergencies and 112 calls, emergency calls, procured by the Generalitat Valenciana of Valencia using neural networks. Or for example, once again, EGASAT using random forest, support vector machines, neural networks, which are classified as black box models. So absence of performance metrics. How is the model performing? No. Are we using confusion matrix, precision, recall, sensitivity? It depends on what we want to measure. No, no presence of that. Only I have seen in 2 contracts relating using or with some specific reference to performance metrics. I will go. This is an explanation of the types of metrics that can be used, and it depends on the purpose. For example, precision is useful when the cost of false positives is high. In healthcare sector, we have a cost. Is cost to assume a false positive? Yes, of course. Vendor lock-in effects at 2 levels. On the one hand, black box models. Why? Because we need to implement techniques for explainability of the models, for especially for the public staff, for the civil servants and the public employees. Are they aware of these techniques? Are they have they some expertise on this technique? We don't know. But in fact, my impression is that in some contracts, the public administration is acquiring artificial intelligence solution because it's fashioned. Because you see in the tender documentation that the technical requirements are very vague, so on. On the other hand, another vendor lock-in effect is the acquisition of proprietary artificial intelligence solutions, pre-packed solutions. We have seen this in 2 contracts. One contract from the hospital in Madrid. It was based in a first acquisition of a specific software, and then they wanted to update the software to optimize the software with new functionalities using artificial intelligence. The same vendor, finally the same vendor. So reducing competition. Another contract was procured by the Andalusian Health Service to the diagnosis of acute ischemic strokes. Acquiring a pre-packed solution as well. So the intellectual property rights management has also an impact. Who is going to assume the intellectual property rights? Who is going to be the holder? It depends on the type of clauses we draft. But for example, in pre-commercial procurement, you may have in mind that, for example, the benefits and the risk of the contract are shared by the public administration and as well by the vendor. So we need to take into account. I have seen different practices on intellectual property rights. And you have some examples if you want to ask after, but these are some examples. For example, in this case, which is a snapshot of the public procurement, of the tender specification. But then, in here, the holdership of the intellectual property rights will be assigned to the vendor. So this may provoke vendor lock-in effects as well. In this case, for example, in this contract, in this requirement, technical requirement, the vendor assigns a license, a non-limited license for the public administration. So it can be a solution, but this solution cannot be probably attractive to the vendor because the vendor wants to exploit the development. So, concluding remarks. After reading some guidelines which are available now, for example, from the International Economic Forum, the UK Office for Artificial Intelligence, also the UK guidance for artificial intelligence in healthcare, Deloitte and Salesforce, Amsterdam clauses. Amsterdam, the city of Amsterdam, has produced standard clauses for final contracts, for final public contracts, taking into account transparency, explainability, governance, and so on. So what are our conclusions? First of all, we need expertise of the contracting authority. And this include skill and multidisciplinary staff. For example, in market consultations, what we have reviewed, the committee, the board analyzing the proposals of the market, sometimes, well, of course, no lawyers. We haven't seen no lawyers, first of all. Then, people with expertise in the area of health, or maybe staff with expertise in the area of computer science or data analysis. But it's very rare to see a multidisciplinary staff. Why you need a multidisciplinary staff? To assess the offers of the tenderers. You need that. Second, we need prior impact assessments that determines the risks and the benefits of the models. No, as you have seen, no impact assessment. We need to clearly define the contract documents. The specific in the document, we need to specify as public administrations the public benefit of the contract. Maybe artificial intelligence is not the best solution for our use case. Maybe we have another alternatives. Selection criteria of bidders, qualification of the working team of the vendor. We need to introduce as a selection criteria that the working team has expertise not only in artificial intelligence, data analysis, computer, for example, architecture, because we need to make interoperable the artificial intelligence system with the legacy systems that the public administration has. But we need also legal. I haven't seen in the tendering documents no reference to legal experts. So this is a risk. In addition, the qualification of the working team as well. In order to avoid vendor lock-in effects, we need to include clauses with reference to prepacked solutions, explainability and interpretability of algorithms. For example, the Alan Turing Institute and the ICO has a guide, a very, very interesting guide on complementary complementary techniques for making algorithmic models explainable. But explainable for whom? For the expert, for everyone. We need to include ethical clauses. I haven't seen any reference to ethical clauses. Maybe we need as a selection criteria, as an awarding criteria, because the Spanish law makes reference to environmental criteria, social criteria, innovation criteria, but maybe we need to include ethical criteria clauses as an awarding criteria in the contract. And finally, establish an adequate monitoring of the mechanisms throughout the whole life of the artificial intelligence system. Of course, taking into account, I put it in red, the classification of high-risk systems in the artificial intelligence proposal, which for me, well, is not the classification, I know that there have been some changes, but the classification, I'm not very happy, especially with healthcare solutions using artificial intelligence. It's not very, it's very vague maybe. So thank you very much.
Thank you. Thank you very much, Estrella. I think we are all very impressed by your analysis of public contracts. Those who know the platform and how contracts or the documents that integrate offers and those who know that, I'm sure we all share this feeling of surprise. So, do you have any questions? Lorenzo, I think? No sé. Lorenzo.
Primero la pregunta en español, luego la paso al inglés.
Está bien si todos entendemos
todos.
español.
Una pregunta relativamente simple para Guillermo es si las exigencias de supervisión humana del artículo del reglamento de inteligencia artificial, si crees que implicarían una intervención humana que llevaría a que no fuera aplicable el artículo 22 del reglamento general. Es decir, como el Reglamento General de Protección de Datos, el artículo 22 y sus específicas garantías es para las decisiones solo automatizadas, que dejaran de ser solo automatizadas. Esa sería la pregunta básica y luego, tenía muchos los temas a comentar con Estrella, pero básicamente has mencionado las cláusulas éticas y, digamos, el llamarle éticas es solo porque queda bien o serían unas cláusulas en los pliegos de condiciones que remitieran al cumplimiento del reglamento de inteligencia artificial en los supuestos en los que sea aplicable y en su caso, y ahí sí que tendría sentido que fueran éticas, en el caso de que no fuera un sistema de alto riesgo, que remitiera a lo mejor al cumplimiento voluntario y que el pliego de condiciones dijera, aunque no es un sistema de alto riesgo, que cumpla este y este apartado del reglamento de inteligencia artificial. Y en la medida en que eso lo exigiera, aunque no sea obligatorio por el reglamento, pues por ahí llamarle éticas. No sé si lo intento traducir o no.
I take advantage of the fact of delivering the microphone. One very, very quick question to Estrella. Do you consider that what we are seeing with the procurement is that public administrations are trying to compensate the lacks of regulation using that kind of of contracts and clauses? And do you consider that will be the trend in the future?
Bueno, contesto en castellano. Efectivamente, Lorenzo, ahí existe una tensión que yo creo que está bien resuelta, porque lo que es el requerimiento del artículo 14 lo que está diciendo es más o menos qué tiene que permitir hacer en la fase de uso, las medidas técnicas que tú implementas durante el desarrollo del sistema, pero no está predeterminando en concreto cómo se debe aplicar en el uso. Es decir, te está diciendo, si tú estás diseñando un sistema para este caso de uso, tiene que permitir esto. Y son, en realidad, por un lado el provider y por otro lado el user o data controller, quien tiene que ver que efectivamente el sistema que va a usar ha sido diseñado para lo que el reglamento de protección de datos le va a pedir después. Es decir, si tú quieres tomar decisiones basadas únicamente en el tratamiento que después tengan un human out of the loop como safeguard para los derechos de los interesados, tienes que ver que el provider haya diseñado el sistema para que eso se permita hacer. O el provider, si quiere ofrecer un servicio que tenga encaje en ese tipo de usos, tendrá que diseñarlo para permitir ese tipo de evaluación, no tanto in the loop, sino out of the loop posterior. Esa tensión existe, pero creo que la propuesta de reglamento lo que hace es decidirlo vosotros en función del uso que le vayáis a dar a la herramienta. Creo que, si la pregunta era esa, creo que va más o menos por ahí la respuesta de la comisión.
Thank you. Do you want me to explain Spanish or English? Oh, okay. So, traduciré. Respecto a las consideraciones éticas que se han preguntado. Bueno, en realidad es que no hay nada, es que no he visto nada, ninguna referencia a... O sea, de la misma manera que un criterio de adjudicación del contrato establecido por la ley de contratos del sector público es la referencia a consideraciones ambientales, sociales, pues por ejemplo, cuestiones de paridad. Eso sí está previsto normalmente en los pliegos o como criterio final de adjudicación, o incluso el carácter innovador del contrato. Claro, cuando entramos a ver si realmente se va a desarrollar un sistema ético, ¿no?, que podríamos discutir sobre, bueno, qué condiciones tendría que cumplir el sistema para que fuera ético, por ejemplo, para introducir la supervisión humana, que es otra cuestión. Es decir, nada, en los pliegos que yo he analizado, nada que ver, o sea, ninguna referencia. Sí que es cierto que puede tener que ver con lo que tú planteabas, yo creo, Andrés. Es decir, tiene que la contratación pública, si no te he entendido mal, tiene que en realidad hacer el trabajo que no ha hecho el legislador. Bueno, claro, respondiendo a los dos, entonces, ¿qué hacemos? Es decir, la administración está contratando, the public procurement, public administration is contracting, is acquiring solutions without taking into account the risks that are very well evidenced. Discrimination, for example, in health sector, there are a lot of literature, even with technical evidences, that, for example, certain prediction tools discriminate BAME. BAME is Black, Asian, and minorities, because the system works with assumptions, specific assumptions. For example, Black people, as they are in the area of nephrology, may present less risk because they have a level of creatine in the blood, which is different to, for example, Caucasian subjects. But this is an assumption based on, for example, the muscles and how the physiology attributes of the Black people. This is an assumption, but maybe, as Sandra Wachter explained yesterday, maybe the assumptions are based on historical patterns and data. So these aren't being correct. So the question, my answer is, so what are we going to do with these risks? What are we going to do? Because the fact is that the public administration has already acquired these solutions. And my impression is with no sometimes with no expert knowledge. It sounds very good, this artificial intelligence, wow, we are very fashion. Well, hold on. Do you have an expert team to deal with this? Do you have the expert team to analyze, to assess the offers, the technical offer of the bidders? Are you ready for that? I'm not sure. And in relation with ethical clauses, my answer is the same. So we need to introduce them somehow. I don't know, but somehow. So that's why the second phase of our research project will be to produce guidelines in order to trying to include these specific safeguards. And Guillermo, I have a question. May I have your permission?
Of course.
So my impression is when you have mentioned automation of bias, that is complacency with the artificial intelligence outcome. So, and I have thought about that in public procurement. Well, the public administration has acquired a solution an artificial intelligence solution driven? Well, so what if we assume maybe you have a human in the loop, but the problem is the human in the loop, the human is relying on the outcome. Imagine triage in emergencies. We have a long waiting list of patients. I don't have too much time to classify my patients. Well, I have a tool, I will follow the tool. What if? I think that the European regulation, the GDPR, is not enough. And especially with the Article 22, when makes a legal basis for the use of automated decisions with impact in relation to public administrations, it says yes, but it has to include appropriate safeguards. Where are the safeguards? Because under the Spanish law, the public sector legal regime law of 2015, the article specifying the automation of administrative process does not provide any safeguard. Thank you.
Thank you.
On automation bias and complacency, that is one of my main concerns. And as I said, I think that first, we probably want humans to rely on the automated decision-making system, because if not, what are we doing? I mean, we are implementing a system that we are not supposed to trust, or what? No? So we want humans to rely on those systems if those systems prove to be accurate on that specific context. And that is good that humans rely. But as my point is that there is a room for human oversight to minimize some of the risks. And there is where we have to first train humans using AI systems to try to identify when the machine is wrong, because there is when we don't want humans relying on technology. And second, that we will, I already pointed out that we need continuous evaluation of how humans are taking those decisions, because only there in real world applications we are going to be able to see whether humans are automatically relying on technology when it's wrong. That is the case where we want to avoid. And yeah, regarding, for me it's obvious that the GDPR is not enough. Not only because I feel that it wasn't, we haven't paid a lot of attention on human intervention in the GDPR. I think that this is a fact, but not only for that. The GDPR is not meant to regulate the whole life cycle of AI, and that is why we have all these proposals coming and we having headaches with them.
Yes.
So.
There's any more questions? Okay.
Thank you. Thank you, Guillermo and Estrella. One question, very brief for each of us, each of you. About the human oversight and human in the loop. I understand that they are not the same thing. And do you have hints on when it's really required? It's probably dependent on the applications because of time constraints, because humans are slow and models are. But also humans are more vulnerable to power structures in there as well. So do you have any kind of ideas on where to actually choose human oversight over humans in the loop, and where it's the other, it should be the other way around? And for Estrella, I think it's really interesting, and I think needed these guidelines that you are going to develop. I think these are needed like the air that we breathe. The thing is, could these guidelines be technology agnostic? In the sense that you actually require to be procured one thing, but you don't mind whether it's AI or it's any other technology. If it's an Excel spreadsheet that works, then might be that is okay. So the question is, if the tender is not requiring AI, but requiring the actual functionalities that the system has to do, would that be better? And because in some cases the tender is not requiring AI, but the provider is actually offering AI, or claiming that what he's doing is AI. So I would like just reflection on that. Thank you.
And after those intellectual questions, a very silly one from my part, because your work derives from your doctoral thesis. So my question is, because maybe someone in the audience is interested, can we know when you intend to publish it? Or is there a possibility to download it in the doctoral thesis version? That would be a very, very silly question, but I am quite sure that there's people interested, and I have also received a WhatsApp asking me to ask that. Okay. And Estrella, the initial results of your research group has been already published, but in your presentation you have more data than the data that you have already published.
No, I have, well,
so in the future
I can answer later.
To publish also.
Yes. We are working. We are going to publish.
The guidelines, there will be more.
Yeah, there are more. There's more.
I'm sure that there's also people interested in them.
Thank you.
Okay, I will go first with a question. I tried to clarify this in the beginning, that if human oversight is not opposed to human intervention in the loop. It's not different, but a more abstract concept that includes, in a big umbrella, humans intervening in the loop, humans intervening out of the loop, reviewing, or whatever. So human oversight in the AI Act proposal is a more abstract concept that includes many kinds of control, intervention, or reviews, and so on. So who has to establish which is the best kind of intervention for each context can be the law. The law, like the GDPR, can tell you have to put here a human in the loop, or in many times you will. This will be a thing that each public administration or each business model will decide where to put humans and how to put humans. Actually, human intervention in the loop in the GDPR, it's a quite broad concept for me, and can include like a flexible models of AI human kind of interactions, even if it says that it has to be a human in the loop intervening. I think that it's a pretty broad and flexible legal framework. The publication. The publication of the book will take at least the end of summer, so probably fall. I'm not yellows of my own copyrights rights, so I can share in Spanish, but also many of the ideas that I have here, for example, are in a preprint that is public that I wrote with Paul de Heert that you mentioned.
Yeah.
He hates and loves me because we don't always agree.
He hates and loves law.
Yeah, but he's awesome. And there you can find some pretty ideas of what I explained. Also, I mean, the work that was awarded by the Data Protection Spanish Authority. It's also public. It's in Spanish and it's meant to be applied to the healthcare context, but it has there some of the ideas. So, but anyway, I don't hesitate to share it with anyone that is interested, like my whole PhD. So that's everything.
Thank you, Guillermo.
Thank you.
So, in relation to technological agnostic approach, yes, in fact, there is a tension between the detailed requirements in the tender documents and requirements focus on functionality and goals of the system. In this sense, I must say that when reviewing all the tender documentations about the 43 tenders we have identified, I must say that sometimes it was quite difficult to identify if there were an artificial intelligence driven solution in the proposal of the public purchaser or not. Sometimes we detected it because it used the term predictive, or we need insightful insights from the data that we have available as administration, and some key terms that led us to think that behind that tendering process was that the public administration wanted an artificial intelligence-driven solution. The problem is that if you only describe the functionalities, the problem is the safeguards. Because I think we are agree that artificial intelligence needs specific safeguards, not the same safeguards of the ordinary software. Goes much beyond, because, for example, we don't know how the artificial intelligence system is going to interact with the legacy systems of the administration. We don't know how it's going to develop itself after training millions and millions of data, after different validations and so on. We don't know. We don't know how will be the final outcome. And it will be, for example, when we deal with technical tools to provide with explainability to black box models. For example, LIME. LIME is a technique, which is focused on the local results. That means, in relation to this instance, to this, for example, this patient with these variables that we are going to consider, how is the model behaving in relation to the cohorts? It will depend of the instance and the variables that we are using. So I think that just only laying the procurement documents on technological and agnostic, which otherwise is required by the European legislation, when it refers to technological neutrality. It refers that we are not acquiring a specific technological solution, but any solution, any technical solution. So my concern is the safeguards, to introduce the safeguards. And in relation to the publication, well, the first phase, was the approach was the impact in public sector. So as I mentioned, it's not open, but I think if you have in your repositories of the university, maybe if you want a reference, I think maybe you will have access very soon, because the results have been published this year in an American law review. So I expect that it will be available in very soon. And in relation to guidance, producing guidance, well, this is the second phase. That means we need to analyze very carefully the tender documents, and we need to compare them to see what is to compare, for example, with the guidance which has been already produced by other stakeholders. And yes, we expect maybe this year or next year, at the beginning of the next year, will be available. And in this sense, I have to thank the director of these two projects, Professor José Vida Fernandez, maybe you know him, because he's from administrative law, and my colleague José Luis Quintana, which is he's a lawyer in a law firm. He's specializing in public procurement. So, but this is a real research project involving different perspectives, and including also technological expert in artificial intelligence. So this is what we were looking for, to understand the technological basis, because this is my final claim. So we as lawyers need to understand the technological process, the functionalities of the system, the technological wording. We need to understand each other. We cannot work. My concern with the literature I have seen is that there are commonplaces referring to the artificial intelligence, black boxes, and discrimination, and so on. Yes, but what else? What else? So we need to deal with that, and we need to work in a multidisciplinary teams. Thank you.
Thank you very much, Estrella. Thank you very much, Guillermo. Thank you to the both of you. I think your presentations have been... we have one last question, of course.
Small one. Legal. Well, thank you. Very interesting. I have two remarks, just because I am very curious about what you are doing. And the first one is about the way you got the survey done. Because I got the impression that you have few documents, and small amount of documents coming from mainly perhaps Nexus, Lexis, and Westlaw, and the legal repositories, right?
It was a sample, just only a sample, but just to give
this
some
is
evidence.
Issue, and perhaps my question was, if you go to Science Direct, so Elsevier and Springer, I am a editor in Springer, and we have it's huge, it's really huge. But you are right. When I'm doing the same kind of surveys, for instance about compliance, what I find is that there are two separate vocabularies, and so one coming from Lexis and from Westlaw and from Ballet and the legal repositories, and the other one coming from the more technical repositories. But if you go there, perhaps you can do the matching. Some language is here with different meanings, but you can do it if you are using some tools to do that.
No, well, I didn't mention, but the very first phase, at least for me, was to review technical literature. When I had no idea about artificial intelligence, but the first thing I said, well, what is this? What we are talking about? What is the difference between artificial intelligence and, for example, statistical methods? Because Sarah Wachter mentioned yesterday the case, for example, for A-level examinations of QUAL. Of QUAL, I reviewed the technical report published by QUAL, which is the regulator of the official exams at that level. And I didn't know if it was an artificial intelligence driven methodology or a statistical, I don't know. Or for example, Parcoursup in France. I've read the technical report made by the Court of Auditors in France, which was amazing. And the same problem, I don't know if they were in relation to the description. So, but sometimes there are some specific wording that recalls me to the technical standards, and yes, I've used the combination, but for legal purposes and for this conference, I mentioned just only these databases of losses, but of course I use more. Just only to pay attention, that you pay attention in the fact that if you combine public procurement and artificial intelligence, the production is still starting.
Second question is very small as well. Is about synthetic data. So when you are producing synthetic data, you don't know really the outcome, and we have no solution for that. So there is really no solution for that. And then the safe words, because lawyers have to figure out how to do, and what to do and how to do. What are exactly the safe words you have in mind in order to take care of the outcome and the impact? Because it's quite impossible to produce, from a scientific point of view, producing something that can anticipate, foresee the outcomes of synthetic reasoning doesn't make sense.
Well, the synthetic data is a solution provided by the Data Protection Authority, the Spanish Data Protection Authority, in their guidelines in relation, maybe Guillermo, you have worked on that. It mentions that, for example, as a security measure to avoid, in order to comply with the minimization principle and privacy by default, it refers specifically to synthetic data. It refers to that.
My meaning, so the meaning of synthetic data, the broad meaning of synthetic data, is that data is able to produce more data in a way that you cannot retrieve. So you don't have the rules that they are following.
Yes, of course, yeah.
And so you don't have a system. And this is not happening only with data. I remember my colleagues 10 years ago working with in robotics.
Yeah.
Even robots do the same thing. So they learn how to make a decision, and then they start doing things that are not planned.
You have, yeah.
How are you going to control that? What are the legal safeguards? There are, but
well, you have to produce. For example, for example, the data protection authorities talk about. Thank you. When the European data protection authorities, for example, the Working Party 29, the supervisor, the committee, the board, talk about safeguards. They are clarify what are the meaning of safeguards. They say identifying the data, identifying, for example, the time limitation period, identifying how you are going to ensure the data protection rights of the subject. They are very specific. It's not that, I mean, we need to produce the legal safeguards. That's one I want to mean. Identify what should be the legal safeguards and producing expressly, not mention to legal safeguards in a vague way. I think we need to produce the safeguards, to identify the safeguards.
With legal effect.
With legal effects, yeah, that's, of course. Yeah.
Okay, thank you very much. I think we are running out of time, so we will move on to the next roundtable. Thank you very much again for your presentations. We have been amazing, and I think the proof of it is the number of questions. Thank you very much. We will continue with the next roundtable, which will be the last one.